Start. That the Constitution has an economic philosophy rooted in socialistic principles, mainly embodied in its directive principles of state policy, is well understood. Stop. However, the question that has often arisen for judicial review concerns how far the state's obligation to subserve the state's obligation to ensure that ownership and control of material resources of the community are so distributed as to subserve the common good and to prevent the working of the economic system to the common detriment is found in Articles 39B and C. Stop. The recent verdict of a 9-judge bench of the Supreme Court, is notably for its examination of whether the underlying economic thought should be given as expensive view or there are limitations on what sort of private property can be the subject of state action. Stop. The court's majority information rejects the expensive view taken in a few precedents in favor of any private resources, including those individual owned, falling under its ambit. Stop. Para. The majority view is that while theoretical, private resources should be part of the community's resources, the relevant consideration for the state to acquire or distribute them in pursuit of the common good will depend on non-exhaustive factors: the nature of the resources and their characteristics, whether such acquisition is essential for the community, the scarcity of such resources, and the consequences of their being concentrated in private hands. Stop. Land acquisition has always been based on the principle of eminent domain, while allocation of natural resources will acquire fair and transparent processes. Stop. On the other hand, nationalization of utilities, services and industries had required constitutional justification, through the directive principles. Stop. The majority is right in holding that the Constitution makers worked Article 39 in broad terms so that they do not tie down the future regimes to any particular strand of economic thought. Stop.